Sorry for the break. Welcome back to our discussion. So just before the break, I was making the point that where there has been breaches of the prohibitions in Section 58, a number of sanctions are applicable, including administrative penalty units, which the Register of Companies may impose on the defaulting company, or in some cases, even the particular officers who are responsible for the default. So let's keep that in mind. I would like to move on to look at Section 59. And at this stage, we have started meeting the exceptions to Section 58. As you remember, Section 58 said that except as provided in this act. And then Section 59, we're going to start meeting some of the exceptions, but before that, I think the hand is up, so let's take that before we move on. Yes, Ajua.
Good evening, my lord.
Good evening.
Yeah, I think you were trying to explain the administrative penalty before you went off. So I thought that you give us a more explanation of that before maybe you go.
Explain that.
Yeah.
Yes, explain that.
Okay, maybe let me just repeat it.
I didn't get that. Okay. Sorry, sir.
Good, no problem. I said that under the old law, that is repealed at 179, whenever there was a default, two types of sentences were possible. Fine, that is, you are made to pay money to the state, or imprisonment, custodial sentence. But under the new law, third possibility has been added, what they call the administrative penalty unit. And the administrative penalty unit is so called because the Register of Companies, which is a regulator as far as incorporated companies are concerned, is given the power under the new law to be able to exact, fines for defaulting companies. But when fines are exacted by the Register of Companies, that we don't call it fine, we call it administrative penalty unit, in order to distinguish it from a fine which the court may impose. So that is so the difference lies in the fact that the Register of Companies can impose those penalty units even before court proceedings kick in. But the fine cannot be imposed unless there has been court proceedings. So that is it. And then I was just making the point that the Register of Companies is giving the power to retain a portion of it internal generated fund for its running. And this will include a percentage of the fees and also the administrative penalty unit as the case may be. But that was just a footnote remark. So let's continue with Section 59. Alteration of number of shares. Section 59(1) makes the point that a company, as a general rule, of course, this is not a rare general rule, because the general rule is what we saw in Section 58, which says that a company cannot alter the number of its shares. But now we are seeing an exception to Section 58(1)(a), that the company may A, increase the number of the shares of the company by creating new shares. So it is permissible for the company to increase the number of its authorized shares or registered shares. So as we noted, a company is registered with a particular number of shares, right? That you're registered with, let's say, 10,000 or 100,000 shares. That will be the registered or the authorized number of shares of the company. And the company cannot issue more shares than its registered number of shares. However, it may well be that the company has even exhausted issuing its registered number of shares, and yet the company may need money and all that. So the company may decide to increase the number of shares by creating new shares. So so you may do the necessary amendment and you file the processes at the Register of Companies, and the number of shares which can be issued will be increased thereby. So let's keep that in mind. Then if we look at the 59B, that a company may reduce the number of the shares of the company by canceling shares which have not been taken or agreed to be taken by a person, or by consolidating its existing shares, whether issued or not, into a smaller number of shares. Let's explain this a little bit more. But before that, we've pointed this out to you before. Look at the where I have put the cursor. That is the May. Okay. If the 58, we saw the company shall not. Now 59.1, the chapeau is saying that a company may. And you know that from our law of interpretation, whenever the word may is used, is permissive. That is to say that it's not mandatory. There's some element of choice or discretion. So a company may reduce the number of its shares. How is that possible? Let's say that the company was originally registered with 100,000 shares, okay? And let's suppose that out of this 100,000 shares, 30,000 shares have been issued. And we still have 70,000 shares unissued. Now the company has become so successful, so prosperous, that when they do their projections and know that the next 10, 20, 30 years or even 40 years, the company does not need any external injection of capital or money. It can naturally operate at a high level and making profit. So the company says that we're not interested in having this unissued number of shares. So let's change, let's get them out. Then those ones can be cancelled as it were. So the emphasis here is that those shares which can be cancelled are those shares which have not been taken or agreed to be taken. Because shares which have been issued to someone, you cannot just take the share back. If you did that, you'll be doing what we call the expropriation, like you are depriving the shareholder of his property. But don't forget, as we noted, a share is a property. So if you've acquired a share from the company, that is your property asset where you have money in it. And it cannot be taken away from you just like that. It must be done in accordance with law. Now, it is also possible to reduce the number of shares of the company. And by doing what we call consolidation, you can reduce the number of shares by doing consolidation. Consolidation, as you can see, the green highlight. And what is consolidation? Consolidation, if you remember, during President Kufuor's term, there was what we called redenomination. I don't know if you remember that. So the idea of the redenomination was that instead of having plenty zeros, we were going to slash off some of the zeros so that we would reduce the the amount. So then in those days, what we called 100 Ghana cedis now, that would probably be the 10,000 or yeah, because you had the 4 zeros. So that no, to be 1 million or I think what we called let me put it on the, let me get the test this and let's look at this. if you really come for Ghana. So, it used to be like this. So 10,000 cedis is equal to 1 Ghana cedi. 1 Ghana cedis, okay? And then, so if you have 100 Ghana cedis now, that will be what? No, sorry.
1 million.
1 million. Okay. Yeah, so, yeah, that'll be, 1 million. Because you add this 1 million. Yeah. So, you wanted to reduce, so those days, it was not uncommon to be carrying plenty money. If you have to get what we call like the KYU or a head porter to carry the money that you're going to deposit in the bank. You have like this huge fertilizer bag or Ghana must go bag, and the money is packed and loaded. It's as heavy as cement blocks, and they're taken to the bank. So we decided to get rid of all that by knocking off the 4 zeros. And so that is why 10,000 old Ghana cedis now become one new Ghana cedi. So in a similar vein, when it comes to the idea of consolidation of shares or consolidating shares, what it simply means is that you want to reduce the number of outstanding shares by combining the shares into manageable units. And what do you mean by that? Let me give you this picture. So let's suppose that the shares are quite huge. One person will say that, okay, I have 10 million shares. Another person, I have 2 million shares. Another person, I have 500,000 shares. I have 60 million shares. So just imagine, it becomes very difficult for you to play around with some of these huge numbers. And especially so, where in the share certificate that you are giving to your shareholders, you have to state the serial number of the shares, and you always want to continue from the last number of share issued. It becomes difficult. So you may want to do consolidation, and you do that by combining a designated or specified number of shares into one share. So what happens is that the value, the market value will remain the same. And just like the redenomination, the value is the same. If it was 10,000 Ghana cedis, we say there is 1 Ghana cedi now, the value is really the same. Amount of goods you can purchase will not change. It's the same thing. So in the same vein, instead of maybe having huge number of shares, right? The company can say that we are going to consolidate our shares. So we are going to come up with a scale and say that for each, let's say, 8,000 share, right? We're going to treat it as one share. So let's suppose that the company, let's say we have A. A has got 1 million shares. Let me bring this thing down here. Let me see. Let me hide this here. Okay, so let's use it. I think we have a bigger space here. Good. So we are trying to illustrate consolidation of shares. Consolidation shares. And we have said that it simply means merging number of shares into a specified number. Into a specified number. We are trying to give an illustration. So we said that we can have, let's say, shareholder, let's say, okay, Amma has got 1 million shares. Kofi has got, okay, 10 million shares. Yeah, has got 10 million shares. Maybe 150 million shares. Good. So the company decided to do consolidation, okay? And this is how the consolidation works. The company will come out with a scale, just similar to the redenomination, and say that for each, let's say, the company can even say that for each 1,000 shares, we are going to count it as 1 share. So 1,000 shares now become equal to 1 share. Now, with this consolidation, what it means is that Amma's share will become, are you with me? Amma's share will become, what did Amma have? Was that 1 million? Yes. So Amma's share, which was 1 million, now will become, we divide it by the 1,000 to become 1,000 what? 1,000 shares. Kofi share will now be what? Kofi share will be 10,000 shares, isn't it? Your shares will now be 150,000 shares. Good. Now, if you look at it, let's do it this way. Let's assume that at the time each of these shareholders bought their shares, okay? At the time that the company issued the shares to them, let's assume that they actually got the shares at 1 Ghana cedis per share, okay? So, therefore, that is the value. But, of course, the value of share is not static. The value of share, the price at which you acquire the share, does not mean that the share will always carry that particular value. And that is why in Ghana, we have abolished what we call the par value concept of shares. We have no par value, meaning that at every point in time, we determine what the true value of share is in terms of interaction of demand and supply, how much people are prepared to pay, or how well the company is performing. So the point being made is that consolidation will bring about reducing the number of the shares in order to bring about sanity. But it will not necessarily reduce the market capitalization of the company. The share of each shareholder would increase or would actually become more manageable than the huge distance. But nothing will happen as far as the value of the company shares is concerned. So let us keep that in mind. So to do this effectively, there have to be understanding, and then resolution is passed. what we call the exchange ratio determination. So this is like, for example, we can call this the exchange ratio. Exchange ratio. Exchange ratio in the sense that now, if you have 1,000 shares, you are going to exchange it for 1 share. Okay. Yeah, so let's keep that in mind. But the consolidation of shares can apply to both issued and non-issued shares. So let's keep that in mind. With respect to reduction of the number of shares, it does not apply to unissued shares. Sorry, it does not apply to issued shares. It applies to unissued shares, okay? But consolidation of shares applies to both issued and, if you like, unissued shares. Let's keep that in mind. So 59.2 makes the point that on the consolidation of shares, the amounts of money paid, an unpaid liability on the shares, and a fixed sum of money by way of dividend or repayment to which the shares were entitled shall also be consolidated. So that is the idea. So the amount of money paid, we are going to consolidate it, or the amount which is yet to be paid, it will be consolidated. And the same thing will also apply to the dividends. But as I said, in substance, the difference will not be much. It will just bring about sanity in how the books of the company look. So 59.3 makes the point that unless otherwise provided in the constitution of a company, the directors may issue shares with rights or restrictions as may be determined by the directors, subject to provisions of this act. Now, of course, we have noted that as a general rule, the company can issue various types of shares, meaning that different bundle of rights will be attached to those shares. So therefore, if you are not in a particular class of shares, you will not enjoy the bundle of rights that go with that particular share. So let's keep that in mind. Then we also noted that, of course, later on when we are discussing directors, we notice that directors are given wide powers, provided they exercise the powers for the good of the company and not for any ulterior motive, as it were. And that is what section 59.3 is actually alluding to. Now let's move on to another exception to the capital maintenance rule, as it were. Section, that's a provision of financial assistance for acquisition of shares. We saw in section 58, I think the 1C, right? 58.1C that as a general rule, a company shall not provide financial assistance for acquisition of its shares. Now that general rule admits of some important exceptions or derogations. And those exceptions or derogations are found in section 60 of Act 992. So therefore, section 60 is to the effect that section 58 does not prohibit any of the following transactions. A, payment of commission or brokerage to a person in consideration of that person subscribing or agreeing to subscribe, or procuring or agreeing to procure subscriptions for any shares in the company, where the payment of commission or brokerage does not exceed 10% of the price at which the shares are issued, or a lesser rate, as may be specified in the constitution of the company. So let's understand this in context, and for purposes of appreciating the dynamics and mechanics of the capital maintenance doctrine, let's listen well. Now, we have seen that a company raises money by issuing shares, and that is why Section 58(1)(c) says that the company should not give money to anybody to acquire its own shares or shares of its holding company. So that's the first point. Now, but if the company has shares to actually issue so as to get money, the company will need services of some people whose job or whose business it is to look for prospective investors in order for them to invest in the company by acquiring the company shares. And those people they are not working for free, they are working to earn a living. So they would like to get payment. Just like just typical the analogy of a landlord and a tenant, or someone who wants to purchase a house. You have your houses, you have rooms or flats to let, but you don't know people who may be interested in renting those available rooms or flats. But we have some people who have made it their job to scout around, look for people who are interested in renting, and also look for people who have property to rent. And then he will bring them together. He gets commission as an agent, real estate agent. The same idea applies to when it comes to shares. There are some companies which are called brokerage companies. Their job to make their platform available to bring investors and businesses or companies looking for capital together. And so therefore, if the company is going to use services of some of those brokers or brokerage firms, then the company will pay for their services. So long as the company is not paying more than 10% of the value of the share, which the company is going to issue, that is not considered as violating the capital maintenance doctrine with respect to providing financial assistance for acquisition of shares. No. So there's a cap. The cap is that don't pay more than 10%, so that let's say that if the share value, right, is 10 cedis, you are not supposed to pay more than 1 cedi as, if you like, a brokerage commission or fee for the brokerage firm helping you to get a shareholder. So long as we stay within that limit, you are not considered as violating the rule which prohibit provision of financial assistance. So let's keep that in mind. B, where the lending of money is part of the ordinary business of the company, or lending is the ordinary business of the company, or lending of money is the ordinary course of business, although the money may be used for the subscription or purchase of shares in the company or its holding shares. Yeah, so here too, if let's suppose you lend money, your bank or some institution permitted to be lending money and all that. You give money to your borrowers, and as soon as they borrow the money, they use the money to come and buy shares in the company. That is also not considered as violating financial assistance rule. Reason being that that company lending of money is its business. It is not lending you the money because you have said you're going to use it to buy shares. That is why it's lending the money. No. Its normal business is with lending money, regardless of what you're going to use the money to, whether you use the money to go to Dubai, to go to pilgrimage, to go and marry or whatever. That is up to you. So in the same vein, if money is lent to you and use it to buy shares, is not violation of prohibition of financial assistance. C, The provision by a company of money for the purchase or subscription of shares to be held for the benefit of persons, generally in the employment of the company or an associated company, including a director holding a salaried employment in the company or an associated company in accordance with a scheme for the term being in force. The simple point about 58C is that there's nothing wrong for a company to make money available, okay, for its employees to acquire shares in the company. And this applies even to executive directors. That is, directors who do not only sit in the boardroom, but they also have a paid position in the company. Now, let's look at it this way. On the face of it, you will think that why will the company give money for employees to buy shares? Is that not violating the capital maintenance doctrine, which says that you should not provide financial assistance for acquisition of your shares? The answer is no, it does not. If you look at corporate governance, jurisprudence from continental Europe, especially Germany and the rest, we will be told that as we provide opportunity for the employees to acquire shares in the company, the employees will feel motivated, they will feel incentivized, and will be encouraged to work harder for the company, knowing that their stake in the company is not just the salary or the allowance due them, but they also have a stake in the prosperity of the company if the company should become more profitable. So that has also got an indirect effect on the capital position of the company. D, the advancing by a company of loans to persons other than directors, generally in the employment of the company or an associated company, with a view to enabling those persons to purchase or subscribe for shares to be held by themselves beneficially and not as nominees for the company or any other person. Now, in the C, the company was giving out money, not a loan necessarily. So the company can have a scheme and, for example, say that we want employees to have stake in this company. So we have an employee, if we like, a shares promotion scheme. Every employee who has been in this company for 5 years or more, they're going to be given a certain amount of money. And that money is for only one purpose, the purpose of you buying shares in the company so that you're a shareholder. So that is what the C was speaking to. D is talking about a varied scenario. And that scenario is this, that the company this time is not doing freebies. It's not just giving out money. The company is actually giving a loan to employees for the purpose of acquiring shares in the company. The only exception is that where some of the employees are directors, they are excluded from taking such a loan for obvious reasons. The directors are those who have to approve the loans. So just imagine if they have to compete with the other employees, they'll be giving the loans to themselves and they will end up buying all the shares of the company. That is why the lawmaker in its wisdom says that when it comes to 59D, the 60D, sorry, the directors who are employees are excluded from the loan, which may be advanced by the company to to enable employees acquire shares in it. Sister E, the payment by a company of a lawful dividend on the shares of the company, although the dividend received by the shareholder is used to discharge a liability on the shares of that shareholder, or to pay money borrowed for the purpose of subscribing or purchasing shares. We learned earlier on that when you have shares in a company and the company makes profit, part of the profit is declared as dividend. And you as a shareholder, the returns that you get for being a shareholder is the dividends which will be paid to you. So where dividends are paid to you, and instead of using it to go and buy new suit or buy new phone or buy the ladies, what did they call it, high heels and things like that, you decide to use it to buy more shares in the company. Or if you are not finished paying for the shares that you are taking from the company, you decide to use the money to go and pay for that. That is also permissible. So there's nothing wrong in using dividends you have acquired from the company in respect of some other shares that you hold by using that money to buy more shares or to pay for some other liability in respect of shares that the company has given you. So that is what the 60 year is speaking to. Then F, in the case of public companies, some or all of whose equity shares are dealt with on an approved stock exchange, in respect of which an application has been made to an approved stock exchange for permission to deal in those shares, the payment of any commission, fees, costs, and expenses, and the giving of any indemnities and warranties, in each case to a person arranging or otherwise involved in an underwriting, placing or sale of securities in the company or any other similar transaction, where an application for permission to deal in those securities has been or is made to an approved stock exchange, and 2, any other financial assistance is given in good faith in the interest of the company. Now, there's a bit of similarity, but not exactly, between 60A and then 60. Under 60A, we are talking about a situation where you get brokerage firms to help you to offload shares to shareholders who are interested in acquiring, or where they even have to do underwriting. They buy it at discount in order to go and sell it. So the company will get its money. The law is saying that that can be done so long as the company is not giving excessive commission to the brokerage. In a similar vein, under 60F, we are talking about where a company is listed on a stock exchange. A company is going to be listed on a stock exchange. And you know, when it comes to stock exchange, there are strict rules. The stock exchange authorities would like serious companies only to have their securities being traded in on the stock exchange. And for that matter, they will set a certain threshold. They will set a certain level of a capital which you should be able to raise from issue of shares before they would, for example, give you a green light to have your shares regularly traded in on the stock exchange. And this may call for what we call IPO, initial public offering and all that, for them to know that, yes, the public have confidence in your company. So you are going to make your shares available to the public and all that, so as to be able to meet the requirements of having your shares listed in on the stock exchange. You may need the services of so many entities and professionals and all that, including some brokerages. to help you to do that. And you need to pay them for those services. So when you pay them, so long as the payments you are making are in good faith in the sense that they are meant to help the company to succeed in getting its shares or securities actually made available to the public and to be eventually be approved for a stock exchange, then that is permissible. So, in a nutshell, these are some of the exceptions to the capital maintenance doctrine. And I will encourage you as students to understand all these details which we are discussing. In examination, you can be invited to discuss an aspect of it and things like that. So keep that in mind. We will pause here and continue at our next class this week. So this week, just bear with me. I'll be meeting you often. But if you cannot join, because I record, you can always play it back. So tomorrow, I'd like to continue with I want to finish the shares, hopefully tomorrow. So we'd like to continue with this. But have a very good night.